editor-in-chief of the Jindal Forum for International and Economic Laws. We are a blog founded in 2020 by two of our alumni, and this event is a past part of our conference on making international law relevant, promises and challenges for India. Justice Lalit will be joining us shortly. He is on campus. We can expect him to be here within the next 10 minutes. Meanwhile, to just start off the discussion theme here and to familiarize you with what to expect, this conference takes for granted at least one assumption that international law in public discourse, in legal academia, in the courtroom, it has not gained the amount of relevance that it should have. It needs more prominence, and that there is something strategically or purely just in terms of a conversation to be had about how we can increase the strategic importance of international law, whether it's human rights, whether it's trade law, whether it's refugee law, whether it's arbitration, how we as scholars can contribute to that discourse by bringing this discipline into the fora on important controversies in India. In the last 2 days, we have had 4 panels from students from the university and from beyond who joined us with their brilliant ideas on all of these different fields within the discipline, human rights, trade, and others. And they spoke about how in many different contexts within India, international law has an important role to play. This is not to say that international law is a panacea, that it has all the solutions for all the problems in the Indian context, but only that when we speak of any incident with reference to domestic law, there is a possibility that international law could have important contributions to make in the same discourse. We were also joined by Professor Dr. Prabhash Ranjan and Professor Shailja Singh, who spoke to us about the state capacity in India and how there are problems with coordination within the government, coordination with industries, and coordination with civil society actors in the implementation, enforcement, and conversation about international law. And to both of them, we are very grateful. And those lectures have been live streamed and recorded on YouTube. So after this event, we will be sure to share with you all of those resources, as well as links to the student panels where these ideas were presented. It is our hope that through Justice Lalit's lecture today, you join us in becoming part of this important conversation that in fact has already begun to take space in the parliament, in the courtroom, in the academy, and even in news fora. You will notice that international law is increasingly cited in any important political dispute or incident, and there is a reason for that. And to investigate that, to see how that can improve, this conference is one of many initiatives that the JFIL as a blog will continue to take. And in that spirit, I'm delighted that we are joined by 2 professors who are faculty advisors to our forum, Professor Ashish Yadav and Professor Mahima Balaji. As Justice Lalit arrives, Professor Balaji and Professor Yadav will be sharing their reflections on, first of all, the conference itself, and second, the main takeaways from Justice Lalit's lecture today. So once again, thank you so much for joining us today. Thank you, professors, for being here. And Justice Lalit will be arriving shortly, so we ask once again for your patience with us for the next few minutes. Thank you. Thank you again, everyone, for your patience. I now invite Professor Mahima Balaji to officially declare today's event open.
I hope you can all hear me. Okay. Hello, everyone, and a very warm welcome. I'm Mahima, and I'm a graduate of Jindal. I went on to do my BCL at Oxford, and I recently joined back as a faculty member. So today I'll spend some time talking a bit about the Jindal Forum for International and Economic Laws, and also very importantly, extend a very warm welcome to Professor Lalit, who's been kind enough to join us today to share his reflections on the theme for our 2023 conference, Making International Law Relevant, Promises and Challenges for India. So in 2020, as undergraduate students, Pushkar Reddy, who presently works with CTIL, and I co-founded JFIL. And as of today, I have had the pleasure and honor of working with our present team for nearly 3 years now, and it's been nothing short of fantastic. So GFIL began with the idea of trying to create a platform for engagement for young academics, professionals, as well as practitioners from the Global South in the space for international law. And this really came to be after Pushkar and I spent a significant amount of time discussing about how there was a dearth in terms of actual engagement with doctrine and a sustained critique of it outside of classroom spaces. Particularly, having been at Jindal for a significant amount of time, we soon realized that we were equipped with lovely opportunities and the ability to engage with it in the form of seminars, electives, as well as stellar faculty and their pedagogies. So in sum, Jindal has really consistently provided for a space to think about international law in a very real sense at the undergraduate level, and it's something that we wanted to tap into. So after significant support from Professor Srijit, various members of the administration, and our brilliant faculty director, Dr. Pallavi Kishore, we began GFIL in April 2020. So we began the forum section of our website to engage with law students across India to contribute to a serious discussion in terms of engaging with contemporary developments in international law. But soon we were inundated with submissions from students across various developing countries, including Nigeria, Bangladesh, Uganda, and Iran. And we decided it was soon time to expand our team. At present, our editorial board consists of 10 brilliant members under whose leadership and direction the forum has really grown leaps and bounds. And the present conference right now is only one of their many successes that they've achieved. And this ultimately brings me to talk here about today. And we're extremely pleased to welcome you all to the closing of our first conference on making international law relevant. On that note, let me take a moment to welcome you all and share my very deep gratitude to Professor Lalit, who has taken the time to be here today and share his most insightful and thoughtful reflections on the theme. While Professor Lalit requires no real introduction per se, I'll keep it quite brief. From his tenure as the Chief Justice of India, his legacy will be known to be one that was marked by tremendous reform and one that was incredibly charged. There were several constitutional benches set up during his period, court proceedings were live streamed, and several cold cases were brought to light. In fact, it was a period that was marked as one that was characterized by maximum efficiency, with over 10,000 cases disposed. And importantly, it's certainly one that's left a long-lasting mark on India's jurisprudence for years to come. Many of the cases dealt with sensitive socio-political issues, including the 2016 demonetization decision, the EWS quota, CAA, and the bail applications of Teesta and Siddiqui Kapan. In fact, there were actual jokes about how court reporters were struggling to keep up with the many brisk developments happening at the Supreme Court, almost as if they were being put to run on a treadmill at the time. I can go on, but rather than making you all wait any longer, I would like to hand the stage to Professor Lalit, and I would just like to conclude by saying that his incredibly positive legacy is going to live on, and we're all incredibly honored and tremendously lucky to have him with us at Jindal. So, Professor Lalit, would you like to take over?
Thanks, Mahima. Everybody who has gathered here as part of the symposium, I was told that very fruitful discussions did happen during the course of last 2 or 3 days. My role today is very, very limited. I'm here to share some of my sort of experiences on contemporary developments in international law as administered, say, in Indian courts. We all know various facets of international law, but some of the issues which regularly keep coming before the court and which engage the attentions of the court every time are normally on admiralty side or custody issues, especially when a single parent chooses to leave the shores of a foreign country with the children or a child. And multiple issues do arise in these matters, and especially the courts are called upon to consider not only the jurisdictional issues in their finest form, but also the welfare issues of the child or the children. And that's a constant tussle which the courts have to undertake, so much so that there have been number of ideas which get thrown up, and the courts do consider or keep oscillating, if I may use that expression, from one end to the other. Like, for instance, the earliest case was Elizabeth Dinshaw, where an American lady had married a Parsi gentleman from this country. Both had settled down in US. They were blessed with a child. And one fine day, this Parsi gentleman boarded a plane along with the child and came to India without even letting the mother know where exactly the child was or the whereabouts of the child. Then finally, after a lot of inquiries, the mother came to know that the child is now along with the father in India, so she filed what is normally called a habeas corpus petition. And the bench presided over by Justice Retd, the judgment is of 1989 or 90, acknowledged the fact that the child was holding an American passport, was a born American, and therefore the primary jurisdiction when it came to the welfare of the child would be that of the American courts. Additionally, the fact that the father had secreted the child was also a pointer which was taken into account by the court, and the custody was granted to that Elizabeth Dinshaw, the mother of the child. Here the father was the one who had secreted away the child, but there have been cases where mothers have done that. Now, in one of the cases which I had the occasion to deal with along with Justice Lokur, the mother came on a temporary kind of arrangement. Both the husband and the wife, they were qualified dentists, settled down in US, both were having passports, both had acquired what is called the natural citizenship of America. They were blessed with 2 children, both holding American passports. And since the going was not so well between the couple, the members, one fine day, the lady, under the pretext that perhaps she wanted to visit the family here in India, came on a temporary arrangement with 2 children. And having come here, she refused to go back. That led to another round of litigation where the husband wanted to have the same kind of treatment which was given to, and the relief which was given to Elizabeth Dinshaw. And that's when some of the basic concepts when it comes to this particular branch came up for consideration. Number one, in that matter, peculiarly, there was a custody order which was obtained by the father in America. And that was the court which was approached for the first time, rather than any other court in India. So two issues. Number one, which courts or which country would have the basic jurisdiction, going by the fact that both the children were Americans. So that was answered in the favor of the father. And the second issue, the court having first dealt with the matter in a custody issue. So relying on what is called comity of courts, that in international law we recognize, we acknowledge, we respect the courts having competent jurisdiction and any dicta or any judgment or orders passed by such courts. The principle of comity of courts would require an Indian court to acknowledge the fact that there is already a process which has been issued by a competent court having jurisdiction, and therefore based on that we agreed to give custody of the children back to the father. It is easier said than done. What happens in such matters is, if the child is just about 3 or 4 years of age, you can't separate the child from the mother. With a lot of persuasion, we could convince the lady that very well she may go back along with the children. The husband will provide for the lady with a separate apartment and everything, so therefore the maintenance and other upkeep issues will be taken care of by the husband, and give it a try that whether the alleged behavior which was projected by the wife to be blameworthy on part of the husband still continues or persists. But that's where one has to draw a line as a court. Where do we draw that line? In another round of cases which came up subsequently, the court rejected the theory of this comity of courts. The courts then said that as competent courts, we are legally bound to consider the welfare issues of the children. So therefore, the paramount consideration has to be the welfare of the child. So in some cases, the courts have refused to grant custody on the ground that it would be disastrous to uproot a child which perhaps has taken roots here. What happens in our normal functioning of the courts is that if the action is initiated, by the time you get down to consider it finally, 2 or 3 years elapse. Within those 2 or 3 years, the child may have taken admission in one of the schools here. He starts gaining or getting roots here in the Indian soil, in the Indian condition, in the Indian environment. And that becomes a compelling circumstance for the courts to consider it favorably in favor of perhaps the parent who had secreted away the child. So we have this constant struggle. Now, one case which I had the occasion to consider lately was a case where a Kenyan businessman married a Punjabi girl here in Delhi. They were blessed with a child. He was holding Kenyan as well as English passports. They were blessed with a child who was also given the same status. And on the 3rd birthday of the child, the family came to India. The husband went back. The wife refused to follow. That led to tremendous amount of bickerings and custody battle between the parties. And one of the issues which the husband wanted to project was that he was a businessman of a great standing in Kenya. He said that the future of the child is in Kenya because there's almost like an empire which I am leaving behind for the child. So therefore, what kind of future do you foresee for the child if he stays back in India? We were constituting a bench of 3 judges. Justice Malhotra and I, we granted custody to the father. Justice Hemant Gupta refused. His is a dissenting note. And we granted custody on the point, and that's where some of these international law issues do come to the fore. Kenya and India do not have any treaty amongst them. They are not signatories to any international convention. As a result of which, any orders passed by the Indian courts are not enforceable straight away in Kenya. So one of the issues which got thrown up during the discussion was whether if you say that there is any violation of the orders passed by this court and the mother is refused even the access, how are you going to enforce that order? So we relied on certain judgments of House of Lords where some mirror orders is a concept which has been employed. That you first go to the court and say that this is what the settlement has been arrived at between the parties and whether this settlement can be recognized by the Kenyan courts. An order was placed on record, based on which we granted the custody to the father. Later it turned out that the father filed a proceeding saying that such kind of order is unknown to law, this mirror order, and wanted to have that order set aside. This is where tremendous complications did arise, which finally led us to the contumacious conduct on part of the husband to recall the order granting custody. Why I am placing all this before you? This is one area where, apart from the consistency and the definiteness of law or the legal provisions, there are human emotions, there are issues like welfare of child, which stand on a completely different footing altogether. Compare it with normal admiralty cases, arrest of a ship. One of the famous cases is one which was dealt with by Justice Saikia way back in almost 91-92, then followed by M.V. Elizabeth, which was dealt with by Dr. Justice T.K. Thoman. The normal concept is very clear that if you have a claim against the ship, in the case decided by Dr. Justice Thoman, it was insurance claim by the insurance companies. And in the first case, it was the claim arising out of the fact that the ship had sold away the goods which were supposed to be consigned and delivered to the consignee. So once the ship entered the territorial waters of this country, the ship was sought to be arrested. And the jurisdiction of the courts in those matters to arrest a ship was acknowledged by Supreme Court. One of the issues in that M.V. Elizabeth was whether the Andhra Pradesh High Court has admiralty jurisdiction or not. That was decided by the court saying that Andhra Pradesh High Court to certain extent was a successor court which derived its jurisdiction originally from Madras High Court. And since Madras High Court was conferred admiralty jurisdiction under the latest patent, so Andhra High Court would certainly have that. Other thought which has been going on is that as a court of justice, as High Court, you must acknowledge that jurisdiction which inheres in the court. What do we gather from this? There is a definiteness in the matter. You normally consider that a ship which has been sailing under a flag of a foreign country, like the principles which are normally available in IPC, that a carrier, a vessel or a ship or an aircraft which is flying under the flag of a foreign country has some special status. But it is accepted in admiralty jurisdiction that the moment such a ship enters the territorial water of this country, then the jurisdiction of this court will certainly extend to that For instance, if an offence is committed on high seas, on such a vessel, then normally the courts in India would not have jurisdiction except when the matter comes within IPC parameters. That is, the offender is an Indian. Certainly, yes. Similar issues actually arose in that Italian Marines case. It was, according to the Italian Marines and as well as the Republic of Italy, the shooting, if at all, had happened on high seas from a vessel which was flying Italian flag. The offenders were Italian nationals, and as such, though the victims were Indians, two fishermen from Kerala coastal part, they seriously challenged the jurisdiction of Indian courts, and that's the judgment by Justice Altamas Kabir and Justice Chalameshwar on the point, which accepted that Indian courts do have jurisdiction. What finally may emerge, whether as a tort or whether as a crime, it could be the inquiry by the court whether these persons are liable or not is a completely different dimension altogether. And that is where some of the very peculiar and at times very delicate balance has to be maintained. Now, those Italian Marines were initially taken in custody, released on bail on the condition that they shall not leave the shores of this country. Now, the natural course of any litigation in this country takes so much of time that the prayer was made on their behalf, saying that allow us to go back to Italy. How does one allow that? So the ambassador of Italy gave a personal undertaking saying that yes, I give personal undertaking that I will abide by this and I shall be responsible in case there is any failure. And lo and behold, there was a situation where these Italian Marines refused to come back. So these are some of the ideas. Of course, we normally have what is called insurance policies, trade, business, arbitration. These are areas which are very, very definite. But the normal functioning of a sovereign and the idea that the sovereign has the power to tax its people and the sovereign has the power to take criminal action against its people gets extended to anybody who is part of or who is within the jurisdiction of that country. And that's where some of the peculiar situations or peculiar fact situations get thrown up for consideration by the court. That's why I chose only these two branches, where what happens in custody battles is that you may acquire citizenship of America, but in your heart of hearts, you are still Indian. And especially when a girl finds that she is without any support or without any moral or without any kind of, functional support from the husband, or the situation becomes too alarming for her, the only solace that she can consider of finding is going back home along with the children. So that's where some of these delicate issues actually arise. I don't know how the discussions have gone ahead in your symposium, but since I was asked to share some of the views which I have gathered, which I had the occasion, and I came across as a judge, so therefore these are 2-3 areas where these matters do have some kind of importance when it comes to courts of law. Like the other bank guarantee issues and other things, you are well aware. I need not bother to tell you about that. Bank guarantees, insurance claims, all the corporate world, all the arbitration issues. These are matters where the law is very, very clear after that judgment of the Supreme Court in Reliance matter. that even two per entities who are Indian entities can actually decide to have the seat of the arbitration outside the country, and the cural law will be that which the parties have decided. So therefore, when it comes to matters which are purely contractual, which are purely commercial, we have a slightly different attitude, and we go by that definiteness or concreteness in the matter. But when it comes to personal issues, that's where the matter becomes slightly, the lines are getting blurred. And that is why the courts are called upon to consider these issues with some kind of, to maintain that delicate balance. This is all that I wanted to share with you. Thank you so much. Thank you.
Thank you so much again, Justice Lalit, for joining us and for your kind reflections. May I now ask Professor Ashish Yadav to join us here on the stage to share the takeaways from this conference, from the speech given by Justice Lalit, and what it means for us.
Thank you, Vijit, and thanks everyone who's here. My first token of thanks to Justice Lalit for those illuminating thoughts. And I'm here to sort of bring a few things together from the very start of this conference, from what has been happening here, from what these words by Justice Lalit tell us, but also to appreciate general developments in international law lately and the promise of initiatives such as this one. So firstly, I think what is quite clear is that courts in India, rather than this contrary view that many students may hold, engage with international law a lot. Because when you sort of do this survey in a public international law class, it is increasingly emerging in classrooms that students find it hard to refer to international law precedents from India. But that doesn't seem to be the case. Courts deal with so many issues of international law in their everyday proceedings. And certainly international law is still so in its so-called nascent stage in India. We need a lot of work to proceed from here to have various doctrines recognized, to perhaps have favorable orders in very predictable international law matters in Indian courts. But these issues are emanating from what I call often the expectation problem in the international law, the expectation deficit with international law. Since its post-war inception, international law as a discipline has had a very tall ask from it. The ask, by some scholars would say, has been of utopia. The task has been the end of humanities. The task has been stop all wars. And it is because of this tall ask, because of these expectations, that international law seemingly never really fulfills them. And it creates this expectation deficit where we are routinely mad at international courts or lawyers, or we are not happy with certain interpretations of international law. But then, when we see recent developments, we see, for example, what happened 2 weeks ago. The US was held accountable at the ICJ against Iran. We see that TWAIL, the Third World Approaches to International Law School, is now more important than ever. It is now a mainstream thought movement. Its scholars are routinely recognized before various international tribunals as well as universities. Of course, we have Professor Chimney here, and more prominently, just last week, Professor Anthony Angie was awarded the Manlio Hudson Medal by American Society of International Law, the first time a TWAILer was recognized. Now, so far you may question, okay, what is the relevance of TWAIL in this larger discussion? The relevance is this, which is that in my experience of teaching at this institution, largely international law, I've come to experience that we don't make the correlation of the importance of TWAIL locally for us as a developing nation, as a country which still has a great deal to achieve in its judicial and its economic progress. The promise of TWAIL and the promise of recent developments is that the future is in the global south. The future is in the global south because the past has been in the global south. And this is sort of my, this is my idea to sort of take us back to the inception of TWAIL, or rather to the inception of the NAM. It happened at a great moment in world history, in 1955, Bandung, Indonesia, where nations came together to realize the promise of international law. And the promise of international law being, some certain principles should be recognized, that all nations must be treated as sovereign equals, that non-interference should be the paramount principle, Article 2.4 of the Charter, that territorial integrity cannot be breached, that there is a right to individual and collective self-defense. And these ideas eventually lead to the establishment of the NAM on this mission that India was a global leader in advancing. And it is through going back to ideas like this that we can underscore the importance and the relevance of international law in the current Indian legal landscape. Since we were at the very founding of it, we were present there and we led that movement. And now we have so many TWAIL scholars who increasingly rely on these principles, and this resurgence on scholarship on Bandung has shown the same. We clearly see that international law is really relevant in India, that even in the routine functioning of Indian courts, we see international legal principles being cited. We see that there seems to be an Asian perspective of international law that has emerged in the last couple of years. And we also see the very charm with international law, as Justice Lalit also mentioned, that routinely Indian judges have been asked to decide on jurisdiction in cases which span multiple geographies. And in the same way, as for those of you who've done your PIL course, you would know that the most often, the first stage of the ICJ, International Court of Justice proceedings, is deciding jurisdiction. And that's the best thing about international law, maybe. It has consent-based jurisdiction. No one can be forced, no state, no country can be forced to be a party to a proceeding which it doesn't want to. So it has a lot to offer. It respects the equality of nations. It respects that each nation has the right to determine which kind of judicial proceeding it wants to subject itself to. And again, the issue of enforcement of awards, as Justice Lalit mentioned, also comes up in routine discussions about international law. What if there's a judgment and the US or another powerful country doesn't follow it? But the survey of ICJ judgments in particular increasingly shows us that international law is followed, that most orders are complied with, that there is, after all, faith in international law. Which brings me to sort of coming back to this conference and the very idea that which is at the inception of it, the heart of it, making international law relevant in India and how that could be done. And so far I've outlined some reasons why international law is relevant, but what could we do in furthering this cause? As instructors, as professors, I see some of my colleagues here, I think it is our responsibility to pedagogically put international law at the heart and center of our teaching. That perhaps the time is gone when we rely on the same old, European or American precedents to talk about maybe even monism and dualism. There are enough precedents from Indian courts. We go back to scholars. We go back to so many Indians who have a lot to say about international law. And we've had this great intellectual tradition since our independence on international law. We have jurists like R.P. Anand, M.C. Chagla, and then this tradition continues to this day. And as students, I think it is really important to perhaps participate in initiatives like these, to take your own scholarship seriously, to go back to the basic principles of the discipline, to then analytically present your argument. But then perhaps most importantly, as some students routinely emerge to take great initiatives, it is important to perhaps have this trust in yourself and build something which you're passionate about, which is what some of these folks who have organized this have done. And I'm so glad to see this happening. I'm so glad to have been associated with some of them over the last couple of years. I'm really proud to be here and to deliver these closing comments. So this is just just little bits on why we should consider international law to be relevant and what we can do in that pursuit. And with this, I will invite Abhijit and his team to deliver the vote of thanks. Thank you very much.
Oh, hello everyone. On behalf of Team JFIL, I am absolutely, it's an absolute pleasure to deliver the vote of thanks today. First of all, we are immeasurably grateful to Justice Lalit for gracing this unique occasion and sharing his reflections with us, which have given us much room for thought and about the future of international law in India. Second, we want to acknowledge Professor Padmanabha Ramanujan, the Dean of Academic Governance of a university, for his tutelage and guidance in organizing this event. Similarly, we are grateful for all the administrative teams from his office who have supported us, including Ratul sir and the AVT. Third, to Professors Mahima Balaji and Ashish Yadav, our faculty advisors, for joining on this important occasion, and to our faculty director, Professor Pallavi Kishore, and our distinguished advisors, Professor Prabhash Ranjan, Professor Aman. We remain ever grateful for your guidance. Finally, to all of you who have joined us in thinking about this vital conversation and the impact of international law in India. And to my fellow members of Team JFIL, thank you for being here. With that said, now I would like to invite Professor Mahima and Professor Ashish Yadav to present Justice Lalit with the mementos.
Thank you so much, everyone, once again for joining us today. Thank you, Justice Lalit. Thank you, Ariman and Team JFIL. With that, I officially declare the talk closed, as also I declare the conference on making international law relevant closed. Hopefully, though, the conversation itself will continue between us, between you, between our distinguished guests. And to that end, thank you once again for being here. And we hope you remain associated with Team JFIL.